One of the first things that happens in your Massachusetts divorce is automatic restraining orders go into place. Automatic restraining orders have a big impact on your financial future, and if you violate the order, can cost you a lot of money. Let's talk about it. What are automatic restraining orders in your Massachusetts divorce? Well, the first thing is it's not a restraining order as in you can't see a person or talk to them and you need to stay away, as restraining orders are in, say, domestic violence criminal cases. The automatic restraining orders we're talking about in your divorce simply prevents you from selling, disposing, or hiding any assets. So if, for instance, if you own real estate together, neither you nor your spouse can sell that real estate during the pendency of your divorce. If you have joint bank accounts, you can't clear out all the money and take it all for yourself. If there's any personal property that you own together, you cannot sell that personal property and use the funds for your own purposes. It also impacts financial accounts such as life insurance, retirement accounts, trusts, and things along those lines. So you cannot clear all that out and keep the money for yourself. Also, if there's health insurance on you and your spouse and children, if you have them, you cannot change people who are covered under that health insurance policy. In addition to all this, you cannot take on any new debt, anything that would encumber or burden your spouse. The accounts, such as bank accounts and the financial accounts, are not frozen. They're still open and can be used, but you cannot convert all of the funds for your own purpose. When do automatic restraining orders go into place? Well, what happens is when the petitioner, that's the person filing the complaint, files the complaint with the court, they are bound by the automatic restraining order. The respondent, or the defendant in the case, is bound by that order once that complaint is served upon them. So once the sheriff hands them the complaint and the summons, part of the paperwork is a copy of the automatic restraining orders. At that point, nobody can dispose of personal property except under certain circumstances. So as I say, these orders are in place automatically, but they can be modified. So they can be modified by agreement between you and your spouse, or they can be modified by a certain court order. If you want to modify the restraining order, you have to file a motion with the court. You have to give at least 2 days notice to the other side, to your spouse, and then you'll go for a hearing. So let's say you need money for a certain purpose and you have assets that could cover that expense. You would go before the court and explain why you need the money and what it is you're looking to sell, and the court would make a decision. If the court agrees with you, they would allow you to sell that particular property and take the proceeds and use it for whatever you need. If your spouse opposes the order, they would come into court and they would argue that, Judge, please leave everything as it is until there's a final order from this court. There are certain exceptions to the restraining orders that you might want to consider. Before we discuss those, however, I just want to let you know that if you are considering divorce or if you are responding to a divorce complaint, we want you to know what you should be considering. Feel free to go to affordlaw.org/checklist. We've come up with 7 of the most important things you should be considering while you're going through the process. So let's take a look at the exceptions. The restraining order lists several exceptions whereby you can dispose of and use the property you have. The first and most reasonable is reasonable living expenses. So obviously you have to pay your rent, you have to pay for food, for gas, for all your living expenses. Those expenses can be used through joint accounts. Another one of the exceptions is funds needed during the ordinary course of business or investing. So let's say you're running a business and you have to pay your employees or you have certain overhead that you have to take care of. Those things can be used through the joint accounts that you have, as long as they are incurred in the normal course of your business. So let's say you've been running a business for a number of years. Every month you have to meet payroll. Clearly, you've established that those funds are needed and you can probably use the money in the joint accounts. Another exception is a written agreement. Perhaps you and your spouse can come to an agreement on certain funds that can be used by one party or the other. Another exception is by order of the court. And as we explained before, you need to go before the court to modify the restraining order and ask the judge for certain things that you need in specific. If you violate the order, you could be held in contempt of court. If you think that the other party is violating the order, you would file a motion for contempt of court. whereby you file the motion and you bring the other party in before the judge, and you basically explain that, hey judge, this person has taken our personal property or sold our real estate or whatever the case may be, and they are in violation of the order of this court. If you are found in contempt of court, it can cost you a lot of money. First of all, the court would order you to return the property so that you and your spouse can split it at some point down the road, and your spouse could also ask for attorney's fees for that contempt hearing. Automatic restraining orders are in place in every Massachusetts divorce. You'll want to know what your rights and obligations are because you don't want to get into trouble with the court. If you have any further questions about Massachusetts divorce, please feel free to visit our next video.